The official rulebook for how companies operate, it's not as dry as it sounds. In fact, it's packed with hidden puzzles, clever loopholes, and secret rules that really define the game of modern business. Today, we're going to decode India's Companies Act using some real-world case studies to see how these rules actually play out.
All right, so here's what's on the docket. First, a math problem that seems impossible. Then we'll question what a border even means when a business lives online. After that, we'll untangle a messy corporate family tree, find a legal shortcut to skip some serious paperwork, and finally, discover how a company can write rules that are even tougher than the law itself. Okay, let's kick things off with a real head-scratcher. It sounds like a riddle. How do you legally fit 230 members into a company that has a strict legal limit of 200? So picture this. There's a company called Flora Fauna Limited. It's a public company, and it has 230 members. They want to go private, but there's a huge problem. The law is crystal clear. A private company can't have more than 200 members. At first glance, it looks like they're totally stuck. I mean, they'd have to kick out 30 people, right? Okay, so let's break down who these 230 people actually are. You've got 50 directors and their relatives, 15 current employees, 10 former employees, 5 couples who own shares together, and then 145 other folks. Add them all up, and you hit 230. It seems pretty open and shut. They're over the limit. But, and this is where it gets really clever, the secret to this whole puzzle is that the Companies Act doesn't actually count every single head. The law is much smarter than just basic arithmetic. It has these specific, little-known exceptions. So who gets a free pass? Well, according to Section 268, a few groups are invisible in the official count. First up, any current employees who are also members, they don't count. Second, any former employees who got their shares while they were working there and still hold them, they don't count either. And finally, this one's my favorite. If you have 2 or more people holding shares together, like a couple, they're treated as just one single member. So let's run the numbers again with our new secret rules. We start with the 145 others, plus the 50 directors and relatives. That's 195. Now those 15 current employees and 10 ex-employees, poof, they're off the list. And the 5 couples, who are 10 people, they now count as just 5 members. So 195 plus 5 gives you exactly 200. Flora Fauna is perfectly legal. It's a fantastic piece of legislation, really, because it encourages companies to give employees shares without punishing them for it. Okay, so we've seen the law can get a little creative with counting people, but what about counting places? Our next puzzle completely rethinks what a company's location even means in our digital age. Let me introduce you to Teresa Limited. They're incorporated in New York. They have 0 physical presence in India, no office, no employees, no agents on the ground, nothing. But they do a ton of business in India completely online through data interchange. So the big question is, does Indian law even see them? Are they considered a foreign company? Well, to figure that out, we just have to look at Section 242 of the Act. And the definition is incredibly clear. A foreign company is one registered outside India that has a place of business in India. But here's the kicker, the part that changes everything. That place of business can be physical, or it can be through electronic mode. And electronic mode isn't just some vague term they threw in there. Oh no, the rules spell it out. We're talking about everything from B2C transactions and data interchange, all the way to web marketing and online education. Basically, if you're doing business online, you're covered. And just like that, the mystery is solved. Teresa Limited, even though its servers are in New York, is absolutely considered a foreign company in India. Why? Because its online data business is its place of business. The big takeaway here is huge. Physical borders don't matter anymore. A digital presence is just as real in the eyes of the law. All right, next up, we're diving into the world of corporate family trees. And trust me, figuring out who's really in charge, who's the holding company, and who's the subsidiary can be just as complicated as any real family drama. So let's look at this structure. At the very top, you have the grandparent company, Piyush Private Limited. It owns 100% of 2 other companies, Jeevan and Sudhir, the parents. And then these 2 parent companies own shares in a third company, the grandchild, Saras. So here's the multi-million-dollar question. Does that automatically make the grandparent, Piyush, the legal boss of the grandchild, Saras? Is just owning the companies that own the shares enough to create that direct control? Well, the law actually gives you 2 distinct paths to becoming a holding company. 2 different ways to prove you're in charge. The first one is the obvious one. You own more than half the shares. The second path is a bit more subtle.
you control the board of directors, meaning you have the power to hire and fire most of them.
Now, in our story, when you add up all the shares that the parent companies, GV and Sudhir, own in Saras, it comes out to less than 50%. So if we only look at that first path, control through shares, the answer is no. Piyush is not the holding company.
But, and this is the crucial twist, let's look at that second path. What if Piyush, the grandparent company, has the power to appoint, say, 8 out of the 9 directors on Saras's board? Well then, bam! Piyush is the holding company. It doesn't matter that it doesn't own a majority of the shares. Controlling the board is just as powerful and legally just as decisive.
Okay, let's be honest. Nobody loves paperwork, right? Especially when you're trying to run a business. Financial reporting is a massive job, but thankfully, the law has a clever little exception that lets some companies skip a big piece of their homework.
So what's usually required? We're talking the whole shebang. According to Section 240, a full financial statement includes 5 major documents: your balance sheet, your profit and loss account, a cash flow statement, a statement of changes in equity, and all the explanatory notes that go with them.
That is a ton of work. But the law is smart. It recognizes that this level of intense detail might be overkill for smaller operations, so it created a very handy exemption. Certain types of companies can file all their financial statements without having to include a cash flow statement.
So who are the lucky ones who get this pass? The list makes a lot of sense. It includes one-person companies, officially defined small companies, dormant companies, which aren't really trading anyway, and private companies that are classified as startups. It's all about easing the burden on the little guys and the new players.
All right, for our final puzzle, we're looking at something really powerful. It's the idea that a company can write its own rules that are even stronger and harder to change than the actual law. The concept is called entrenchment.
Let's take the case of Yadav Dairy Products. The Companies Act has a standard procedure for changing a company's internal rules. It's called a special resolution. But what if this company wanted to make one specific rule practically untouchable? Could they write into their own rule book that to change, say, the rule about forfeiting shares, you need an overwhelming 90% majority vote?
And the answer is absolutely yes, they can. This is what's known as an entrenchment provision. It's a legal mechanism that lets a company basically say, for this specific thing, the normal rules aren't good enough. We're setting the bar way higher. Think of it like putting a constitutional lock on one of your company's core beliefs.
So why is this so important? Well, it's a massive strategic tool. A founder could use it to entrench the company's charitable mission, making it nearly impossible for future owners to get rid of it. Or, as we've seen in another case, a founder could use it to entrench their own job as a director for life, safeguarding their original vision for the company.
So, what we've seen today is that the Companies Act isn't just a stuffy, rigid rulebook. It's actually a flexible, strategic toolkit. It's a game with rules that can be bent, interpreted, and even strengthened. Which leaves me with one final question for you. If business is a game, how would you write the rules to make sure you win?